Let me proceed possible. Down.
But we are tired of standing there.
I don't want to give him a chair.
And this is
Which chairs were?
So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
Nga bakiri nti munnange lubaale w'omulamu tasamirirwa ababaddeyo ku kkooti wali e Makindye nga Dr. Kizza Besigye aleeteddwa mu musango gavumenti mwe muvunaanira okubeera nti nno abadde alina omuzungu gwakukuta naye munnansi wa Bungereza nga ekigendererwa kyakufuna mundu kujjako gavumenti ya Museveni era wabaddeyo kusika omuguwa ku kkooti gw'amaanyi Martha Karua abaddeyo newankubadde tasobodde kubeera nga akiikirira Dr. Kizza Besigye kuba abadde talina abakola kale Byanyima takkiriziddwa kubeera ng'ayogerako ne bbaawe nga bali bombi okuleka mpozi nga waliwo abasirikale abawuliriza buli kimu ne balooya tebakkiriziddwa kubeera nga boogerako ne Besigye nga tewaliwo basirikale bawuliriza wabadde balina okubaawo abawuliriza tewabaddewo privacy naye kankuwe event emu ku emu okusinziira ku ebyo ebibaddeyo okuviira ddala wabweru ne munda mu kkooti okusika omuguwa okubaddewo paka gye biggweredde.
As I don't sit up, I want to go with you and down. Then I will come and
No, it is instructions.
not accepting.
No, it's closed.
okay. Then let me proceed possible. Down.
But we are tired of standing there.
I don't want to give him a chair.
And this is
Which chairs were?
Let me come.
Okay, we shall wait here.
We shall wait
Let's
from
wait
here.
here.
May it please court chairman and other court members, before we proceed to have a ruling of this court.
Excuse me, we are still proceeding. Please, you let us first finish our submission.
Please sit down.
Thank you very much.
Sit down.
We are still proceeding as defense counsel. We shall not allow you to proceed. Listen, as we are proceeding as a defense team, we have not finished.
Okay, let them finish their part, then you will reply.
No. So the council has no locus. This is what I'm going to talk about.
No. I have all the locusts. Even
No, I
in East
mean
Africa.
the one
What
you are
is that?
introducing.
What are you talking about?
We are not for a fight.
So, Mr. Chairman,
It's their turn. You leave them, let the defense lawyers put up their argument.
Mr. Chairman, the prayer we are making, if we could be given time to interact with their chosen persons, considering the prevailing circumstances where we have the lead counsel who has that issue, who is incapacitated as of now. So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
Council.
I mean, Chairman and members of this honorable court, if I may put this point succinctly, is that the defense team requests this honorable court to talk to the clients, Besigye and Rutare, and then we get effective instructions on how to proceed, because this is not going to be business as usual. Thank you very much.
I wish council you could reduce on your tune. That one has no problem. Council Lord Mayor, what time do you want to talk to him now, or you want to talk to him any other day?
No, we want to talk to him right now, but in the camera, not in public here.
Yes, we can also allow that if it is not going maybe to take a long time.
Like 30 minutes?
Yes.
I think, sir, there are legal issues before you allow them. One, the lead counsel, you are saying she has no instructions as of now. So if she has no instructions, are you saying the case cannot proceed with all these other lawyers you have introduced? And if you are not ready until she acquires a certificate, then it would mean nothing can proceed. Either you seek an adjournment another date, but giving them the minutes still will not make a difference. Because he's saying he cannot proceed without their lead counsel, who is improperly before court.
Honorable Chair, I was very clear. The instructions given are to the effect that Honorable Martha Karua takes charge as the lead counsel. And there are some legal hurdles we have encountered along the way. It is his decision to take any other decision if he so wishes. So this is the matter. This is the issue we are raising. That if there is any adjustment to the instructions, we need to confer with him or with them. So the question is, all along we have been seated outside, we have not had any opportunity of interacting with him. So right now, that's basically what we are seeking for. Like a 30 minutes, we agree. We decide on the way forward, we chart a way forward after having a conversation with him over these issues. I am sure he's just getting information about what we have been doing at the law council just right now here. We had not yet even briefed him as to the progress of the matter before the law council. And these are the issues we should be discussing with him.
And for the avoidance of doubt, that's why Honorable Martha is not yet speaking. We want to talk to the two clients so that they allow us, in the meantime for today, to proceed without Honorable Martha leading the team formally, because they may ask themselves that we chose Honorable Martha to lead and we see Lukwago and Karibara. No, so we are trying to consult them to make them appreciate. So for now, Lukwago and Ernest are leading, as you have seen, and they are requesting, the team is requesting to confer with the client for 30 minutes in the camera so that we can effectively represent them. Yes, thank you very much.
You can hear from state because he wanted to talk. They said he was within their time. Can you address court before the chair takes a decision?
Okay, Council Lukwago has introduced a battalion of lawyers, but among them, I think it is only 4 who have complied with Regulation 62 of Uganda People's Defense Forces procedures. That is paragraph 3. And those ones who have complied are Lukwago, Chiza, Narukora, and Masiko. So I think the rest should not be on record. Yes, they have not complied. Read the regulation. Unless they comply with this regulation, they should not be on record. Person is entitled to appear as advocates.
Order, please.
So I will simply go to paragraph 3. If an accused is to be defended at his court-martial by an advocate not nominated by the convening authority, the accused shall give the convening authority notice of his fact not less than 24 hours before his trial. So it is only those 4 who have complied with that. Even the document, this document here, which is before court, it is as if it is coming from this court. It is a Republic of Uganda, Uganda People's Defense Forces, in the General Court Martial, ordered at Machide. So this document does not bear the address of this
Signed by you.
I don't know even if the person who signed it. I don't know the person. So these people are not properly before this honorable court.
I think Council Lukwago, this goes back to what our judge advocate advised. Maybe to sort out these issues, you could pray for an adjournment and you clearly put everything right.
Prosecution is misleading this court. The instrument is reading was about law firms. It's not about the particulars of the individual advocates. Actually, where I was reading, my name is not there. It's Lukwago and Company Advocates. If we cared enough to look at the list I was reading, he would see the individual advocates and the law firm they come from. They are indicated there. So this is the list. So there's a difference between law firms and individual practicing advocates. For example, Martha Karua on this list is care of Lukwago and Company Advocates. And it is in black and white. So I don't know, his point is neither here nor there. To me, Mr. Chairman, it be considered as a very serious matter. And in any case, the lawyers are here. If you want their particulars, we can furnish them to court. They are here. So those are the things the Constitution intended to cure. Article 126. Maybe it's not applicable in this court. But if the Constitution is the fundamental law of the land here, it's very clear. Substantive justice as opposed to those minor technicalities, which are neither here nor there. So I don't think we should indulge in those gymnastics, Mr. Chairman.
These are not minor technicalities. Mr. Lukwago, you endeavored to attach your practicing certificate. Here you did. This is reimbursed deed. And this is in compliance with the law. Why did you do this? So those ones who have not complied shouldn't be on record. Why did you do it at your colleagues? Or why didn't you advise your colleagues also to do the same?
So I don't understand his prayer. Is he suggesting that the lawyers who are not on this list shouldn't even be here? I don't know the prayer he's making.
No, they shouldn't be on the record.
Yes?
They shouldn't be on the record. I think you have not appreciated the regulation. It is not my law. Read it.
I think I want to reiterate the position of the Honorable Mayor that my colleague in uniform is on a mission to mislead this Honorable Court, and he's doing well in that direction. If he had taken the time to read Article 28 of the Constitution, which I'm going to read for him, Article 28(1) guarantees the right to a fair hearing and guarantees the right to a lawyer of his choice and defense facilities. Article 44, paragraph C of the same Constitution says that this right is not negotiable in my language, but in its speculation it uses English of non-derogable. Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Paragraph C is the right to a fair hearing. The right to a fair hearing includes the two accused persons choosing their lawyer, which they have done. You can't tell them, even now they can appoint a lawyer. Now as we're proceeding, they can even fire us and replace us. That's fair hearing. That rule you are quoting is null and void. Article 2 of the Constitution is very clear that if any regulation, rule, speech from the prosecution is inconsistent with the Constitution, the words of the Constitution, Chairman and members of this court, is such a things as he is saying are null and void. That is Article 2 of the Constitution. Will this court follow null and void submissions, or will it follow the provisions of this Constitution? Thank you very much.
I don't know where my colleague has gotten the jurisdiction to pronounce the law null and void. Read Article 137.
Said regulations, not the law.
It is a law regulating the law. So where do you get the mandate? You hear
Raphael, you have...
I went to law school for 5 years, studied law, and this constitution was promulgated in 1995, and Article 221, these articles are in my head, says that UPDF shall promote, respect, and protect this constitution and the fundamental human rights of Ugandans. And we are saying the right...
My dismay to the humiliating body search that I was subjected to twice, and all members of the legal profession were subjected to. First at the gate, then as we entered the courtroom, another body search. And I'm asking the officers, between the gate and here, and most people have left their briefcases at the gate. What would make them subject us to a second body search? Secondly, I have not yet had audience, the right of audience in court, because I'm not yet licensed to practice in Uganda. I'm expecting a special license to be issued by the Law Council. As it has been indicated, I applied last week. I was informed that they do not process digital applications. So my physical application was brought on Wednesday, and it was taken by the law firm of Lukwago and Company. And it has not yet been processed, but I have been promised by the chair of the Law Council, Justice Mulyangoja, that we may hear from them as early as tomorrow. We have been able to have audience with our client in the court, within the court precincts, and our client was very firm that we ought to apply for adjournment. I should say our clients, not client, so that we can get the answer from the Law Council. You can see for yourself the harassment we have to endure, that they cannot wait even for a minute for this conversation to happen. I want to agree with my colleague, the Lord Mayor, that the abduction of Mr. Besigye and Mr. Lutale from Kenya breaches the Constitution of Kenya, the Constitution of Uganda, and the East African Treaty. I have looked at the charge sheet. The offenses are alleged to have been committed in Kenya, Greece, and Switzerland. Unless if Uganda has annexed Kenya, and we do not know, Ugandan authorities have no jurisdiction whatsoever on anything committed on Kenyan soil. That is, if at all any offense was committed. So we will be raising many objections. I am coordinating Pan-African lawyers from Nigeria, from Kenya, from Ghana, from various jurisdictions, including Tanzania, who will also be applying to practice. As Pan-African lawyers and politicians, we are taking this matter very seriously. We are going to stand in solidarity, and we will file other cases in the East African Community Court, EACJ, against Kenya and Uganda for their illegal conduct. We will be exploring all legal options, and I'm very hopeful that tomorrow I'll be granted a license to practice in Uganda, and that the Law Council will be ready to to process other multiple applications.
Indeed, there are going to be multiple applications. They should get prepared. Uganda from Martha.
First of all, we take exception to the manner in which we are treated here as lawyers, because we have been subjected to some horrendous treatment here by the forces that that are in charge of this place. Right from the checkpoint, the first checkpoint there, where they subjected us to some thorough search, which was uncalled for, forcing us to leave some of our gadgets there, including vital instruments like handsets, because ordinarily when you go to a court, you must be equipped with all the tools that you need to discharge your duties as counsel. And the phone these days is a computer. And actually, for us, we are modest enough. We do not carry huge gadgets like laptops, iPads, and whatnot. We just wanted to use our phones to be able to make reference to the authorities, the cases, the volumes of laws. You know, the huge volumes of laws of Uganda, which you cannot carry here. If you were to do that, it would be truckloads. But in modern times, that is a given. You cannot stop lawyers from accessing the premises of this tribunal with the gadgets. We didn't expect that to arise as an issue. But I don't know why they had to make hair out of that, make it a little contentious, and they delayed us here. Just a simple matter. And also subjecting our senior counsel here to that demeaning, denigrating, and embarrassing treatment that they subjected her to. We condemn that in the strongest terms possible. But finally, when we were allowed to access the premises, still there were issues, because in the morning we had to visit the office of the law counsel. Unfortunately, we didn't find even a single senior officer. We just found their cleaners. It was coming to 9 p.m. because we wanted to first... no, it was coming to 9 a.m., sorry. We wanted to first get clearance. You are aware, Senior Counsel Martha Karua, who is the team leader here, submitted in her application for a special practicing certificate last week on 27th, and we had to bring hard copies. And prior to that, soft copies had been forwarded to the Secretary Law Council, and for us, we thought that would be sufficient. They would act on that. We are in a digital age. Unfortunately, they insisted on physical copies, which were delivered on the 27th day of this month, of last month. That was Wednesday last week. And it comes as a surprise to us that they were not processed till the weekend. And since we did not hear from them, because they didn't favor us with any response, we gave them a benefit of doubt and said, okay, fine, let's cross-check with them and see if there are outstanding issues they wanted to first handle. So this morning, we made it a point to accompany our senior colleague here to the law council. Unfortunately, nobody was there, as I said. But we managed to talk to the chairperson, Justice Irene Muriagonja, on phone. They had a conversation, a telephone conversation with the senior counsel Martha Karua here. When she assured us that they are working on the application, they are processing the papers, that most probably by tomorrow, we may hear from them on the decision they will have taken. The papers were thorough, the application, accompanied by a communication from the Law Society of Kenya and a copy of our practicing certificate, and also an introductory letter from the office of from our law chambers, to which is attached in accordance with the Section 18 of the Act. So, when we appeared here, our team was not properly constituted in circumstances where the lead counsel had no audience before this court. You are aware it was coming up for ruling on preliminary matters of law that we raised the day they were arraigned before court here. So we could not proceed under those circumstances. When we had the conference and conferred with the accused persons, we agreed that yes, we can have this matter stood over for just one day. We fast tracked the process of securing the temporary certificate for our counsel here. Unfortunately, the court could not accommodate us. They have adjourned it to the 7th day. That is to the 10th day rather. That is next week. Of course, that to us was rather unfair because you know our clients have been incarcerated. Initially, they were in illegal detention under the military courts here. And as you also know, up to now, they have not been properly processed through the immigration. They are still considered to be visitors of Kenya. As we speak today, they are still visitors of Kenya. The immigration of Kenya and Uganda has never cleared them to cross back here. And of course, there are issues of rights. But by and large, the environment you have witnessed here is not conducive, is not concomitant with the dictates of rule of law, good governance, and most importantly, dispensation of justice. So as lawyers, we are determined today, we are only 35 who appeared here, and they had to take us through those rigorous processes of accessing the chambers here, which was really uncalled for. But next time we appear here, the number is going to be much bigger. And it is on that note that I will request our senior counsel, who is our team leader, to brief you on how we are going to proceed as a legal team. I thank you.